My name is Paul Brown. The legal update for this year was given by Jenny Wigley of Number 5 Chambers. Jenny, I wonder if I could start by asking you, of the cases over this year, is there one that you would single out as perhaps the most important? And if so, why?
Well, that's obviously quite a difficult question. The obvious one that most people would go to would be the Supreme Court decision, because that is obviously the highest authority. I wouldn't necessarily pick that. I'd perhaps pick East Staffs, or Barnwood Land, as it's otherwise referred to, which clarifies changes all the outcomes for the conflicting High Court decisions on the presumption in favour of sustainable development and paragraph 14, and makes very clear that the presumption in favour of sustainable development only operates within paragraph 14. Development that might otherwise be thought sustainable does not benefit from the presumption in favour of sustainable development. It also clarifies other aspects of paragraph 14. But putting all that to one side, I think actually the most important case of this year and the most striking case of this year is the case which finds Natural England to be irrational. It's very rare, almost unheard of, for the court to find a planning decision maker irrational, never mind a statutory consultee like Natural England, where the court held that Natural England's advice was lacking all empirical and logical basis and was irrational for that reason. That's the Wealden case, which was examining the in-combination effects between two core strategies which would lead to an increase in traffic flows near to an SAC. Because Natural England failed to add those two up, do an amalgamation of the impacts of the two core strategies, it was described as irrational and the relevant policies were quashed. So whilst there are very important cases on paragraph 14 and the presumption in sustainable development, the most striking is actually, in my view, that case on irrationality, because it's so rare.
Thank you. We've also had a number of cases on heritage. Every year produces its crop of heritage and greenbelt cases. What do the decisions that we've had this year tell us that we haven't previously known about the application of heritage policy?
Twofold, I'd say. One is that paragraph 141 of the NPPF, which isn't used that much, isn't referred to that much, is not to be interpreted literally, I think, is the outcome. A decision in Hayes against York Council, Mr. Justice Kerr decided that it couldn't be interpreted literally, because on a literal interpretation, paragraph 141 says that the commitment to record heritage evidence when heritage artefacts are lost, that commitment to record cannot be a factor in a planning determination. The court held that must be wrong, and it must really mean that it cannot be a decisive factor in that determination. And the judge had regard to previous iterations of the policy, which he said introduced a non sequitur into the policy wording, which needed to be disregarded. And as a result, he felt comfortable in implying an additional word into the policy. So the outcome of that is that the ability to record evidence can be a factor as long as it's not a decisive factor. The other case I wanted to mention is on setting. What is the ambit of setting? What relationship does there need to be between a heritage asset and a development site for there to be an impact on setting? The Court of Appeal case in Powys and Williams emphasises a visual connection being necessary, but then the High Court case of Mrs. Justice Lang in Steer actually quashed a inspector's decision for only considering the visual impact and failing to consider whether there might be a historical or economic connection, which could mean that the public's understanding of the heritage asset could be impacted on, and that therefore there could be an impact on setting. So at the moment, it would appear that setting goes wider than visual factors only, but that decision is being appealed to the Court of Appeal. So again, we may get some news on that soon. Yeah.
It seems astonishing that there are still any questions about Greenbelt to which the case law doesn't already provide an answer, but there are always new cases emerging. What's been happening this year?
Well, yes, there are, and there have been. Paragraph 89 on the definition of appropriate or inappropriate development in the Greenbelt sets out the exception for new buildings. One of those is appropriate facilities for sport, as long as it preserves the openness of the Greenbelt. The High Court decision in Elmbridge and Boot this year makes clear that that is a very strict policy. It applies to decision taking. It has to be applied in a strict binary way, and any impact on openness at all, and quite often there'll always be an impact on openness with a new building, but any impact on openness at all takes that building outside of that exception for inappropriate development and means that very special circumstances have to be demonstrated.
And finally, Jenny, one of the more colourful cases this year, the litigation involving the infamous Stripey House in Kensington and Chelsea. There have been decisions there, both in terms of the planning permission, but perhaps the one that caught the public's attention was the decision on the painting of the building itself. What does the decision in that case tell us?
Yes, that was a very interesting and colourful case, and obviously the background to that is quite interesting in that Mrs. Lyle Mainwaring painted her house in a reported fit a peak against her neighbours, and the council sought to enforce that, probably prompted by complaints from neighbours, on the basis of a Section 215 notice, on the basis that the condition of the building adversely affected the amenity of the area. She appealed against it and won the appeal both through the Magistrates' Court and the Crown Court. But in a judicial review, Mr. Justice Gilbert was very clear that a Section 215 notice cannot be used in that way. It can't be used to enforce aesthetic preferences, and it can't be used, importantly, can't be used to take away permitted development rights. And of course, house painting is a permitted development right and can only be taken away by an Article 4 direction. So 215, it says quite a lot about what 215 can be used for. It's really directed towards maintenance type issues rather than taking away rights. It can't be used to take away rights. So that's what we know about it. But we also know that we're free now to paint our houses in any colour we like, particularly if we want to upset our neighbours.
Yes,
So.
of course, it doesn't mean that the councils have no power to deal with it. There are other provisions.
Yes, of course. There's like the Article 4 direction, for example.
Yes, but those would engage compensation or at least advance notice being given.
Yeah.
Jenny, thank you for a wonderful paper this year, a very useful paper. For those who want to look further, full copies of it are available in the written document. Jenny, thank you very much indeed.
Thank you.